My name's Bob Chris. I'm a litigation partner here in Chicago, and I work very closely with the technology group on a variety of matters, including software development disputes, outsourcing disputes, and cybersecurity. Over the years, I have been involved in assisting clients in responding to data breaches on a real-time basis. I've defended clients in data breach class actions, and I have provided advice on how to develop written information security plans and data breach response plans. And this morning, I'm going to be talking about cybersecurity legal requirements today and tomorrow, and how to minimize liability risk in changing times. During the course of my remarks this morning, I'm going to be addressing three questions. What is the current legal approach to cybersecurity in the United States? How might that approach change in the future? And what can my company, or your company, I should say, do to minimize liability risk in this evolving legal environment? Now, my remarks are going to be at a high level, big picture remarks. I am not going to give you a survey of all the laws that are applicable to all companies. There just simply is not enough time, and that's not the point of my remarks. What I'm trying to accomplish today is to give you some sense of where I think the law is going in this area and some suggestions as to how your company can minimize its legal risks in this area given the changing environment and the uncertainty in the law governing cybersecurity. So let's begin by looking at the current situation and looking at the regulatory approach. We'll look at the judicial approach in a few minutes. Virtually all states and some federal agencies now have requirements that you give notice within a certain period of time after there's a data breach involving sensitive information. And it's a patchwork. You know, different types of information trigger the requirement in different states. There are different periods in which you have to respond and give notice. But that's a general approach that is nationwide, and there's been a lot of ink spilled on how to respond and how quickly to respond to the data breaches. What is new and what I see developing is some states and some federal agencies taking a step and saying you have an obligation to prevent data breaches. You have an obligation to implement certain safeguards to minimize the risk that a data breach will even occur. And often in these situations, there is a requirement that you conduct a risk assessment, and then you do what's reasonable in response to the risk that you identify. And for a long time, that was really all the guidance that the states and the federal government were giving. Basically reasonableness, almost like a negligence standard. Doesn't identify or explain what's reasonable, just leaves it to a balancing of interest. But now we are starting to see a few states and some federal agencies taking some next steps and actually identifying some specific safeguards that have to be implemented, or at least have to be considered. And if they aren't implemented, you have to explain why you aren't implementing them. So let's take a look at some examples. We're going to go coast to coast. We're going to look at New York first. New York very recently has enacted, the New York State Department of Financial Services has promulgated cybersecurity requirements for financial services companies. Their approach, again, do a risk assessment, identify what is unique to your company as risks, and take a reasonable response to those risks. But in addition, encrypt information at rest or transmitted over external networks, or have some sort of alternative compensating control and explain why that control is as good as encryption, or makes more sense in your setting than encryption. Multi-factor authentication for external access, again, or reasonable equivalent controls. Regular cybersecurity training for all personnel, penetration testing, vulnerability assessments on a regular basis, application security. You heard about this morning, privacy by design, security by design, actually training people to think about that when they're doing the coding. So these are specifics. They have to be considered now. It isn't just general reasonableness. You have to actually confront things, and things that can cost money, which will get people's attention, like encryption. So let's travel all the way across the country to California. The California law requires reasonable security procedures and practices appropriate to the nature of the information. That's that general reasonableness approach that I was talking about. But the California Attorney General has recently said what that means in her opinion. What that means in her opinion is that the companies have addressed 20 of the CIS critical security controls that have been published by the CIS organization, that Center for Internet Security. Now, I would just like to see a show of hands. How many people have heard about the CIS 20 critical security controls? Okay, not too many people, so I'm glad that I'm raising them, because they have very specific requirements. Multi-factor authentication for remote access and administrative access, encryption of information over public networks, continuous vulnerability assessments, installation of malware protection. These are specific things that the California Attorney General is telling people that if you don't do this, if you don't address these issues, and you have a data breach that could have been prevented by some of these, I'm going to come after you and argue that you didn't have reasonable security procedures. This is something that is a developing trend, I believe. There are going to be more and more statements of what are sort of minimal standards that have to be addressed. So on the federal side, we've got the FTC, which you've heard about this morning as one of the primary agencies for cybersecurity, and they bring enforcement actions under Section 5 of the FTC Act, which prohibits unfair and deceptive trade practices. The approach the FTC has always taken in this area is case by case. It's kind of like a negligence case, like a medical malpractice case. You know, they don't announce with rules everything that needs to be done, but they look at what's done, and if they think that something, that a breach occurred because there was a failure to act reasonably, they'll bring an enforcement action. And a hotel chain, the Wyndham Hotel chain, was the target of an enforcement action when they had a serious data breach, and they took on the FTC, and they said, this is not fair. You heard about this, a little bit about this this morning in another setting. Another party is trying the same argument, but their argument was, you didn't tell us what was reasonable, what we needed to do by promulgating any rules, and now you're coming after us saying that we didn't act reasonably. That's a violation of due process. It's not following the Administrative Procedure Act. There needed to be rules promulgated, notice and comment, et cetera, et cetera. And the FTC came back and said, you know, we've done this for years. This is the way we do it. You can't identify everything that could be unreasonable. Things change. And anyway, there's enough information out there that you should be able to determine what's reasonable. And the Third Circuit agreed with the FTC. So that approach by the FTC to do it on a case-by-case basis has been affirmed, and they're going to continue doing that, I believe. However, they, I think, recognized that there was some merit to what Wyndham had to say. And so what they have done is, let me try and get this clock just down here. What they have done is they have issued a guidance document, FTC Start with Security, a Guide for Business. Now, again, I'm going to ask, how many people have heard of this document? Okay, some more people. Good. Okay. A very, very important, very helpful document. And what does it do? It looks at practical lessons that have been learned based upon 50 or more cases that the FTC has brought, and it identifies things that the FTC believes are necessary, required practices, such as limiting access to information on a need-to-know basis, complex and unique passwords, limiting the number of unsuccessful attempts to log in, encryption, segmenting networks to isolate sensitive data, application security again, including provisions requiring security precautions in service provider contracts. So they're identifying the things that have bothered them in the past, and they're saying to all of us, look at these and address them. Because if you have a breach and it's a result of failing to implement any of these things that they've looked at before, they may very well come after you. So they're trying to hedge their bets. They're not issuing rules, promulgating rules through the normal process, but they are providing this guidance. HIPAA, a different approach, again, requires the risk assessment that we've talked about and responding to risks that are identified that are specific to your company. But HIPAA specifies particular safeguards that must be implemented, such as developing a disaster recovery plan. And it also requires that there are certain items that have to be addressed. Again, encryption is an example I keep coming back to because, one, it's expensive and gets the client's attention a lot. But two, in my world, in court, if I ever got to the point where I had to argue, were there adequate steps taken? If I can say something was encrypted, I think I'm going to make a good impression on the judge and the jury. So encryption is a big deal, and HIPAA requires you to consider it and either encrypt or have a reason why you didn't think it was necessary and document that reason contemporaneously in your files, that you went through that process, considered it, and had a rationale for not encrypting if you don't encrypt. Final example, Federal Information Security Management Act. This is applicable to federal agencies and private contractors who work with the federal agencies. The approach here is a little bit different. Requires identification and classification of the information you have in terms of how sensitive is it. And then it says, go to this document, NIST 853, and boy, what a document this is. I mean, it's a really, really thick document. And it has like menus of controls, different baseline controls for different level of risk. Very, very high risk information. This is your baseline of controls to consider. And the agencies are admonished to select from that menu those safeguards that are necessary in order to protect information of a certain sensitivity. On the class action litigation front, plaintiffs have a lot of hurdles to clear. Standing is the first hurdle, motions to dismiss for failure to state a claim, class certification, liability, damages. Let's look at where things stand in each of these phases at this point. Class action standing. 10 years ago, I might not even be standing here because these cases generally got dismissed on standing grounds. The argument being that the risk of identity theft was too uncertain across the class to justify standing, which requires a certainly impending harm. And so many of these cases, most of these cases were dismissed, or if they didn't get dismissed on standing grounds, they would get settled. I was even talking with lawyers, plaintiffs' lawyers years ago, waiting to have a judge talk about, to address our settlement agreement, and they were throwing up their hands saying, I don't know how we're going to really persist in this area because we seem to get knocked out a lot in standing, and we have all these issues, and boy, the world has changed. In the last 3 years, we're seeing rulings from courts, particularly across the street here in Chicago, 7th Circuit, saying, look, if it's a deliberate data breach, why do you think they breached? Why do you think they acquired the data? They acquired it to use it, and that's enough. That's enough to establish that there's a substantial risk that there will be harm, and enough to establish standing. And yet there are some circuits that still require some evidence of actual misuse of the data before there was standing. So now we're seeing, I think, a trend of, you can't be sure which way it's going to go given this split, but there is reason to be concerned that it may go the 7th Circuit route, which means that there will be more instances when these cases go further than standing. On motions to dismiss, the most common claims, breach of implied contract, negligence, violation of the State Consumer Protection Act, unjust enrichment. declaratory judgment, injunction to prevent future breaches. In many cases, at least one of these claims survives. So what I'm seeing is standing, might lose standing, probably going to lose a motion to dismiss, and at least one claim will survive. So you're off and running much further than you were 10 years ago. The highest risk claims, unjust enrichment, and a claim for declaratory judgment and an injunction to prevent future breach. Why? Because damages are much more easy to prove here, or there aren't even damages. You don't have these individual issues with all the class members of trying to determine how they were damaged, which would make class certification very, very difficult. We recently were successful in having these claims dismissed, the unjust enrichment and the declaratory judgment claims dismissed. The only claims that survived were implied contract and the state Consumer Protection Act claim. And as a result of that, we actually were able to settle the case on an individual basis for extremely reasonable amount. So, you know, it really matters that you go through this process and that you're somehow you're successful in getting rid of those two types of claims. Because if those claims had survived, they could have used those claims, particularly the Declaratory Judgment Act claim, to really have leverage against our client. Because you're talking about having a judge review your data security and deciding what you need to do in order to meet industry standards, and that can be enormously expensive and intrusive. Class certification. You know, we're always talking about, you know, the cybersecurity risks and litigation and liability, but I think it's important to take a step back and realize that until March of this year, no contested consumer class has ever been certified. And there's only been a couple cases that even reached that procedural point. And that's because cases generally got dismissed or they got settled. And so very few cases have gotten to this point. We now have a class of banks that were suing a retailer for the cost of changing out the credit cards. That was certified in the Target case. And very recently, a class of consumers was certified in a case that involved a healthcare provider. But that's it. So as a result of that, as we stand here today, sit here today, there is no authority that tells us how will courts address what is adequate security and how do you determine damages in this type of case. There just isn't any law on that yet. So let's talk about the future. In the state and federal regulation area, I think that we're going to see more, more rules imposing additional specific requirements like I showed you before. I think we're going to see more of that. And the question, I think, will be, will these rules form a safe harbor where if you comply with them, you're good? Or are they just going to be a minimum? My sense is that as a practical matter, they may be a safe harbor, because if these rules are promulgated and you comply with those rules, if you do at least a reasonable risk assessment and response to your risk assessment, I think it's unlikely that the regulators are going to be coming after you, just because of the way they've acted so far in trying to give people notice. If they're actually trying to give people notice and people are responding to that, I doubt that they're going to suddenly pull out all sorts of new things and go after companies with enforcement actions. But we'll see. The FTC will likely continue on a case-by-case approach. I mean, they fought so hard to keep that principle, and I expect they will continue to enforce on a case-by-case. But I think they, too, are going to be constantly revising that document that we saw a little while ago, giving people more guidance as to what they are concerned about before they start to go after people. I think they've learned that this Wyndham case, although they won it, they're on kind of shaky ground. And I think they'd like to avoid further litigation by giving guidance before they act. In the class action litigation area, I think we're going to see more class certification disputes, and we're going to see if classes will actually get certified here. And I think that since we've seen this development in the law of standing, where courts are sort of bending over backwards to find standing compared to what they did 10 years ago, I think that they might do the same with class certification. Because, I mean, think about it. Why would you go, you know, as far as they have with regard to finding standing, only to basically, as a practical matter, undermine the litigation entirely by saying you can never have a class? Because if you can't have a class, it's not likely to proceed. So I'm thinking that there is a reasonable likelihood that we're going to see classes certified, and we're going to see then this question of how do we determine what is adequate security in a courtroom. And I think that it's going to come down to, if we ever get to this point of really considering what is adequate security, something like a medical malpractice case. You're going to see a battle of experts on the stand. They were both going to have their opinions as to, you know, what should have been in place that would have prevented the data breach, and what are they going to do to support their position. I believe they're going to be relying upon these very specific requirements that we've just been talking about, that the state and federal government are issuing as to, you know, what are minimal standards. I think what we're seeing is the development of a basic standard of care that would be applicable in these kinds of cases. And I also think that they would refer to consulting reports. This is what is done in medical cases, too. They look at the protocols of the hospital, and if you violated a protocol in the hospital, then, you know, you have a malpractice issue. And so if you have consulting reports that tell you you should do X, Y, and Z, and you didn't do Y and Z could have prevented the breach, then you may have a problem. So I'll talk about this in a moment. These consulting reports are really important to prepare properly. As to damages, there is precedent that the damages have to be determined on an individual basis. At the end of the day, if you lose everything, you know, the plaintiff's going to have to march in and they're going to have to make their case on an individual basis. If that holds, the actual exposure in these cases, if they ever get all the way to this point, could be really quite small because, one, there may not be many people who are injured, you know, as a result of the data breach that are victims of the identity theft. But two, who's going to be interested in coming in and making the case and actually presenting their own evidence and maybe being cross-examined? But that is what the current law says has to happen. But plaintiffs, I expect, are going to try to push this toward some sort of remedy where they can do it on a class-wide basis. And they'll do it, I think, by maybe arguing that there ought to be lost time damages that are based upon averages and statistical sampling, or they may argue that there should be payment for credit monitoring for the whole class, whether anybody sustained that cost at all, to prevent this from happening or to limit the damages. And that really adds up. I mean, we're talking anywhere between you know, $100 and $200 a year. How many years? You have a 6 million member class. You could be talking about Armageddon. And that is the area that troubles me the most, frankly, in this area, is what's going to happen with this issue, if, you know, down the road, if ever we get there. There are good arguments to argue against it, standing arguments that it's really remote as to any individual if they haven't already been hacked, whether they will be in the future. It's sort of analogous to medical monitoring. In the asbestos cases, people were seeking medical monitoring costs to avoid, you know, injury down the road. And at first there were some states that went that route, but now most states say no. I think that, you know, if you don't give medical monitoring for somebody who could die of asbestos, you probably are not inclined to give, you know, data breach protection to those who, in all likelihood, statistically, are not going to be victims of identity theft, but we'll see. And I think it's this uncertainty about the damages that's going to drive settlements in the future. I mean, in most cases do get settled if you don't get them dismissed, and I think what's really driving it is nobody knows how this is going to come out. There aren't any cases on it yet. But you can see a scenario where it's really, really ugly for the defendant, and you can see a scenario where it's really, really good for the defendant. And so the plaintiff's lawyers are looking at this and thinking, well, geez, you know, I don't want to push it too far. I might get nothing. You know, if I try this case and they're only, you know, $10,000 in damages, I won't get any attorney's fees. And the other side of the corporation's looking at it and say, my goodness, if they give credit monitoring to the whole class, I'm bankrupt. So, you know, this is what I think will be driving continual settlement, but reasonable settlements. I mean, I think that both sides have reason to be reasonable. Just very briefly, Internet of Things, that was very nicely handled this morning. I won't get into it any further than to say from a litigation standpoint, I think that, you know, given the potential seriousness of physical harm, courts are going to be very tempted to find standing. Some of these early cases have been dismissed on standing grounds. There's a lot of rationale for that. But, you know, again, judges are human beings, and if somebody might actually get killed or badly hurt, they might very well find standing and might find a way to give injunctive relief. So Internet of Things could become a very active area for the plaintiff's bar. Risk mitigation. So in a rapidly changing environment with quite a bit of uncertainty, what can you do to mitigate your risks? Well, first, if you have customer contracts, make sure that you've excluded liability for negligence, because negligence is where this whole discussion is at, essentially. And also make it real clear that you're negating any implied contractual obligations to take care of the data any further than what you provide in the contract. Address that issue in the contract so there are no implied contract obligations, because that implied contract claim is one that seems to survive these motions to dismiss. If you have, as I'm sure you do, privacy policies online, make sure that you don't overpromise, that you don't say, I have state-of-the-art systems in place, because, one, nobody knows what state-of-the-art is, but it's enough to have a judge say, maybe an issue of fact here, so no motion to dismiss is granted, it's denied, and you're off on discovery. So be very, very low-key about what you're saying in your privacy policies about data security, and develop a written information security plan and data breach response plan. And I urge you, do it in a way that is litigation-friendly and persuasive, and that means one document, you know, that you can put Exhibit A on, not like 10, 20, 30 different documents that circulate around the company, something specific. And maybe it has an executive summary that really explains the rationale in a way that's very persuasive, that, you know, a judge or jury can follow, and they can understand that you did the right thing to try to minimize your risks. You need to think about that policy not only in terms of the technology implications, but also litigation implications, because it could be your Exhibit A in a successful defense of a data breach case. And in putting that together, you will want to have a, let's see what we got here. You need a framework for the standards. And you certainly have to do a risk assessment and address your unique risks. Everybody requires that. You also now have to determine your legal requirements and the guidance documents that are expressly applicable to your company. And you've got to do that continuously because it's fast moving. Things are changing quickly here. But here's something that I suggest that you also consider. We talked about the specific guidance that the states and the federal government are giving. They may not apply to your company, but and technically in terms of the regulations, but they may very well apply to your company in court, because they are developing a minimum standard of care. And so you can think about these in two ways. You can think of them as a sword or a shield. And as a sword, they may be used by plaintiffs saying, you know, look, this is doable, this is credible, and you didn't do it and you had a data breach. For example, WannaCry. If people complied with the CIS critical security controls, they would have been fully patched by May. They didn't, and they had this issue. So that's how a plaintiff would say, you know, you didn't act reasonably. This is an indication of what people think is reasonable. You didn't do it, and you had a data event. How can it be a shield? It can be a shield because if you identify a couple credible bodies of regulations that are endorsed by government bodies and you have actually applied them in your data security plan, you can get into court and argue that you have reasonable security. So on the one hand, there's somewhat more rigorous regulation going on, but on the other hand, you may have something like a safer channel to protect yourself if you comply with the guidance that you are given. My wish list as a lawyer, if I get into this position and I have to defend this, I want to be able to go into court with my Exhibit A, written information security plan that says I did the risk assessment, here's the way I responded to the specific risk, and I looked at the FTC guidance and the CIS critical security controls, and I've addressed them all. I think I can win summary judgment if I can go into court with that type of written information security plan, because it really is persuasive, I think, to a judge and a jury that the company, my client, has acted reasonably to mitigate the risks. You can never be 100%, and people recognize that. But most of these breaches that are occurring are not occurring because of exotic things. It's occurring because people fail to do things like patching within a reasonable period of time. So finally, I mentioned the consulting reports. Be very careful with consulting reports. They can be very helpful to you, or they can be the Exhibit A of your opponent. If they are couched in terms of, you know, gaps in security, immature system, it'll become more mature in 2 or 3 years. There are these requirements, best practices, et cetera, and you haven't complied with everything they told you, you may have a situation where it's like in the hospital, here's the protocol, this is what they were told to do, they didn't do it, they had to breach their liable. So you need to be careful how you proceed with this, and I think having a lawyer involved at the very beginning to talk. I mean, before anybody writes anything, talk. Have the expert, the lawyer, the client talking about these different frameworks. Look at the frameworks, read about them ahead of time. Which one is reasonable? Which one could you possibly achieve? Don't pick one that is so, like the 853, which is like 400 pages. Don't, you know, if you're not going to do it, and you can tell by reading it, no way I'm going to do that, don't adopt that as your structure. Adopt something else that is more doable. And then talk about things before you start putting things in writing. And ultimately, what you put in writing, you put in writing in terms of addressable safeguards to enhance security, as opposed to requirements necessary to have reasonable security. You got to have reasonable security at all times. I mean, if your plan says we'll have a mature system in 3 years and you have a breach before the 3-year mark, you've got a problem. And you didn't need to have that problem. Words really matter, concepts really matter, and you can get all the benefits you can from the consultants without creating adverse evidence if you do it the right way. That's what I have to say this morning. Any questions? I'd be happy to answer. Okay, thank you very much.